Well, again, thank you everyone for taking the time and joining us today in today's webinar. We wanted to welcome you to today's webinar. We are very happy to have with us today Zach Lichtblau from the firm Bonnard Lawson, which is an international law firm. Zach has been practicing law in China for the last 16 years. And in today's webinar, we will be reviewing some of the details from China's new personal information protection law and how that may affect the way we manage data in our companies, and including security management, which is really what we are as Blue Ocean, what we are mainly focused on. And you'll see from today's webinar that it really touches on all aspects of the business. So as security professionals, we definitely need to be aware of these developments. And this is not going on only in China. We're seeing this trend in many countries around the world in various flavors. A couple housekeeping points. This is recorded, and we'll be recording this and sharing this recording with everybody that RSVP'd for this webinar. So you'll have that for your consumption later if you wish. There is also a Q&A window you'll see on your panel. And you feel free to add any questions there at any time. We will address those questions at the end of the presentation. There is also a chat window if you want to send something to me quickly or to the panelists, which we'll be monitoring at the same time. Okay, great. So with that done, I'll pass everything over to Zach. So please, Zach, take it over. Thank you.
Thank you, Ron. So my name is Zach Lichtblau, and I'm currently managing the Shanghai operations of Bonnard Lawson. I'm also a principal in Equasia Corporate Advisory. And in terms of my background and the services that we provide, we focus on the legal support for foreign companies that operate in China. This starts in the early stages before entry to do some sort of legal feasibility studies. It includes advice through the process of incorporating a China entity, from a corporate governance perspective, labor law perspective, and then throughout the life of an organization in China, continued legal support in labor law issues, commercial contracts, dealing with compliance issues, which is the focus today, and also dispute resolution and exit strategies whenever relevant. The focus of the presentation today is the PRC's draft personal information protection law, which is one of the most important pieces of legislation in the pipeline for 2021. To introduce this topic and to give you a little bit of background, and I'm sure some of you are already aware of the topic of data protection and data privacy. Data protection is basically a wider area that includes in it data privacy, which is protecting the rights of data subjects, also including the security element of making sure that data doesn't leak, and it's protected from criminals that are trying to collect data and misuse it. Data protection is important for individuals. As members of society, we do feel better when we know that we have the right to control our own information. For companies, it's important because it allows them to demonstrate being good corporate citizens and caring about the data of individuals that they control, as well as making sure that they don't suffer the penalties that are involved with data leakage or mishandling of personal data. For data protection professionals, this type of legislation offers an opportunity to provide new sets of services to clients, and therefore it is important also for data protection professionals to know this type of legislation. The PIPL is a part of a trend of recent years of legislation all throughout the world, putting more focus on the rights of individuals and the obligations of organizations to protect personal data. The most landmark legislation worldwide in this sphere was the 2016 GDPR, or General Data Protection Regulations, adopted by the European Union. Another important one is the California CCPA, California Consumer Privacy Act, which is expected to be amended this year. And in this slide, you can see also examples of additional legislation that is either has been adopted already or is expected to be coming soon. GDPR is considered by many to be the gold standard or the most strict data protection legislation so far. And as we will see, the PIPL has adopted a lot of the principles of GDPR. So those of you who are familiar with GDPR can definitely use GDPR as a measure to understand PIPL better. The PIPL has not been adopted yet, so this is a big disclaimer. Everything we're talking about today, this is not yet legislation. And in any case, we should not, you should not view this presentation as legal advice. Of course, every company would have its own circumstances, and things may still change by the time that the legislation is adopted. However, many view the last draft that was circulated to the public as expected to be very similar to the law once it's accepted. The PIPL has several principles. Those would be also familiar to those of you that are that know the GDPR. The first principle is legality, meaning that when information is being gathered or it's being maintained, it needs to be done lawfully for a legal. It has to have, you need to have a legal basis for the collection of information, for the storage of information and its processing. There needs to be an explicit purpose for both the collection, the storage, and the processing of the data. The idea, the next element of minimum necessity means that you should not hold data that you do not need or that does not fulfill the explicit purpose, and you should not hold it for longer than you need it. Transparency means that the data subject needs to be aware of the way that their data is being handled and stored and processed, and who has access to it.
Hey, Saki,
Accountability.
can I stop you there?
Yeah.
What is a data subject? Just make sure that everybody understands that means, because you'll probably
Sure.
be using that a lot.
Yeah, so I'll be using data subject. Data subject is actually a term from GDPR, but it basically means each of us is a data subject because we have personal data. So our data is out there, and whoever has our data has obligation to us as the data subject. So when I'm talking about data subject, I'm talking about individuals whose rights we are protecting. And that ties in with the next principle of accountability, which means that the data handlers, the people that process the data, they are accountable towards the data subjects. And the last element is data security, meaning how the data is being stored and making sure that the data doesn't leak and that the company has the appropriate procedures in place to both ensure that data doesn't leak and to deal with events of potential leakage of data. Okay. It might be good to, I mean, we mentioned data subject, but it might be good to add a few other important terms. When we're talking about personal information, which is the first two letters of this law, this refers to any type of information, if it's recorded by electronic or other means, so it could also be on paper, that identifies or can identify a natural person. So this could be name, location, email address, photos, and this type of data, I mean, this requirement, being able to identify, is what constitutes data as personal data, or information as personal information. Anonymization is the process by which personal information is disconnected with a specific natural person. So let's say that we collect data for statistical purposes, and we are able to connect the data subject to the data. Anonymization is the process by which the data subject is disconnected with the information. So we have data of, let's say, how many people prefer a certain flavor, but we don't know their name. Personal information handling is the process of collecting, storing, using, processing, transmitting, providing, publishing personal information. So any type of handling of personal information is personal information handling. There could be other activities that I didn't mention here that would be classified as personal information handling, but this would depend on a case-by-case basis. The fourth definition that is important is cross-border transfer, which is particularly important for international organizations. It means the transmission of collected personal information from one jurisdiction to another. This is a very sensitive issue, and it would probably be one of the most important issues that international companies will have to deal with, including e-commerce platforms, etc. So a few features of the PIPL include its extraterritorial effect. By extraterritorial effect, I mean that the law applies to organizations and individuals that process personal information within the borders of the PRC, even if they are not PRC established. This is particular in these cases. One, when they provide goods or services to natural persons within the PRC, when they analyze or assess natural persons' activities within the PRC, or as very common in PRC legislation, we have a basket clause, if it's stipulated in other laws and regulations. So if you're not a PRC company, but you would have access to PRC data, you need to be aware of this law. If you're going to have access to data of PRC individuals, the law would require you to appoint a dedicated entity or representative in the PRC. Another important aspect, again, a little bit similar to those of you who know GDPR, this would look familiar, although not exactly the same. There are 6 lawful bases for collecting and handling personal information. The first one, which is maybe the most common one that you hear when you hear people talking about privacy legislation and data protection legislation, is the individual's consent. This normally refers to explicit consent in the context of PIPL, again, similar to GDPR. If an individual has consented to the collection of their data, this could be a lawful basis for collecting and processing their data. But it's not the only basis. The other bases include contractual obligations. So if this data is required for the fulfillment of the contract with the individual, legal duties, responsibilities, and obligations. This would cover, for example, if you're a government department that you have a duty to collect the information. This could be, this actually also falls under 5, which is public interest issues. There is number 4 is in the case of a sudden public health incident. We can see here the influence of the last year on the legislation. And as I mentioned, like in all other Chinese legislations, there's always a basket clause that includes everything else. That's other circumstances are stipulated. That's the opening to include in other legislation reasons to collect personal information. The issue of cross-border transfer is something that I mentioned already. It's actually also mentioned in other legislation in China, but GDPR, since its application is probably the widest, is important to understand this law's specific approach to it. So in order to transfer personal data to other countries, the handlers need to meet at least one of the following requirements. The first one is passing a security assessment by the CAC. The CAC, the Cyberspace Administration of China, that's the government department that is responsible for the enforcement of this law. You could also obtain a certification which would be provided by the CAC. The third element is establishing an agreement with the foreign receiving party. So this would be something that would be within the control of the data handler without the need for government approval. And there could be other laws that the CAC will stipulate. I should mention that the law does mention that in case the volumes of data are large, and I assume that this would be stipulated somewhere, is what is considered to be a large volume of data, the security assessment would be mandatory. Yeah. The next feature is the rights of individuals. It's important to understand these rights because these, if you're a data handler, these are the rights that you are obligated to protect. So the individual has rights before the data is being handled. That is to know that the data is being handled, to decide if the data is going to be handled, to limit the purpose of the handling of the data, or to refuse to handle the data, to refuse that the data is handled. They also have rights once the data is being handled to access the data, to copy the data, to correct or complete the data, or to have the data deleted. What has been dubbed in the EU as the right to be forgotten. The last aspect that I wanted to mention to you is the legal liability. This is something that the GDPR got famous for. You can actually look for it online. You'll find a list of penalties that have been issued by different government departments around Europe to violators of the GDPR. PIPL adopted similar types of fines. Even the amounts are similar, if not higher than those that were introduced by in the GDPR. So we see for violations of the security measures, we're talking about 1 million for the handlers and between 10,000 renminbi to 100,000 for the people that are actually handling the data. And for other violations, the maximum is the higher between 50 million renminbi to 5% of the annual revenue of the business. So that could be much higher. Also, a business license revocation is a possible penalty, and there may also be criminal liability, which I think does not apply in GDPR. In terms of next steps, we are actually waiting for the legislation to pass, but I would strongly recommend that companies that are active in China already get to know the draft legislation and start preparing and take actions. We still don't know what kind of grace period there may be, if there's going to be a grace period. In GDPR, there was one. This legislation, at least the draft, does not really mention that. And we may see something that would be like when the legislation is passed, maybe there will be provisions that say, well, it would only come into effect in a few months, or that there will be a suspension in the enforcement, but this is still not clear. So we would recommend that companies start getting to know the legislation, because it is likely that this draft legislation will become law. So what actions are required by the PIPL? One would be creating an internal management structure and rules within the organization to handle data and to manage the handling of data within the organization. There should be adoption of corresponding technical security measures. That would include physical measures like safes, but of course also cyber measures, software, and limiting the access to data on a need-to-know basis within the organization, encryption, etc. Determining operation limit, yeah, that's actually connects to what I said in 2. Regularly conducting security education within the organization and training for employees that have access to data, and formulating security incident response plans. So how do we stop a data leakage? Who do we inform? When? Who is responsible for that inside the organization? All of these procedures should be in place. If we get started on this type of process, what we would recommend is that the companies first start by conducting a data mapping of the company's practices. What kind of data do we have? How do we collect data? Why do we collect data? And how do we store it and process it? We should formulate policies and procedures according to the PIPL principles. So to make sure that we are able to protect the rights of data subjects, and we are able to respond for requests by data subjects, for example, to delete their data. We need to make sure that all the personnel that will handle the personal information will have the specific compliance training. We need to adopt measures to safeguard the security of the personal data and implement security incident response plans, and create clear and organized structure for handling operations and monitoring, report, and acting on the proper maintenance of the data. So that has been my presentation. I hope that this has been enlightening, and I'm ready to take your questions if you have any. Hopefully you have some.
Great. Well, thank you, Zahi. Yeah, we have a couple here. I'm going to start off, and just to put a bit more context here, Zahi was giving a broad introduction about this new law that's going to be affecting all of us. And in terms of data, you might think of it like in terms of client data, which most companies will have, and that's one aspect of this. But more relevant to our industry, to security, it's also things like our employee data, how we're dealing with that in access control systems or other security systems, how we're dealing with video, how we're dealing with visitor management. We have visitors coming to our facilities, how we're saving that data, for example. So all that would be relevant to this. So when Zahi mentioned like to map the data, as a security director, as a security professional, you might want to start thinking about how is all the security related data that's touching on individuals, how are you collecting that, how are you managing that, where is it being stored, how is it being handled, who has access to it, what types of breaches might happen. So that's just the security context to a lot of things that Zahi was talking about. So in terms of questions, if we need to, based on what you're saying, it seems that there's going to be a statutory need to have an actual written policy about how we're going to manage this. Would that be accurate?
Yes. So, I mean, the law specifically mentions that you need to take all these measures. So not taking the measures, not having the right procedures in place could constitute a violation. So it's, and again, I pointed at the GDPR as an example. If you will look for the types of penalties that companies have received, many times they've been penalized for not having the right procedures in place. Obviously, if there's also a data breach, that just makes things worse. But even not having the procedures in place is already a violation, even if no specific right of an individual has been violated, or that we can demonstrate that the rights were not protected.
Okay.
This is, so having the right procedures in place is both an important tool in making sure that the other elements of the law are adhered to, but it's also an obligation within itself.
Right. Okay. Here's a question. What about visitor management? If you have visitors coming to your office, like clients or suppliers, et cetera, and they're in your facility, you're taking pictures of them, you might even give them a badge to enter the building. Does this cover that as well? And would we need to ask their permission for that?
Well, I think that if somebody comes to your building and they would be signing their name, I guess, in the register or providing you personal information, it may be good to have them sign some sort of a consent form that the data that they provided is going to be stored for X period. I don't know what your requirements are in different facilities, but that they are aware, or they can sign that they've consented for their data to be collected for this purpose, for the purpose of ensuring security, and only for that purpose.
Okay.
Yeah.
Now,
and if those individuals contact you and say, like, I want to make sure that you delete my data, you need to be able to delete their data.
Okay. Is this law only related to Chinese nationals, Chinese citizens, or also to non-Chinese citizens in China?
By the way that it's drafted, it talks about individuals within the territory of the People's Republic of China. So whether you're Chinese or a foreigner, that should apply to you if you're in China.
Okay. Now, this is a question for me. I understand, I think we talked about this before, that does the law stipulate that you have to identify a individual within your organization with the role of managing this or overseeing this?
Yes, you do need to appoint a person to be managing this, but so that's more from an obligation perspective. But if you really want to do it right, I would say that it cannot just be that one person. So it needs to really permeate within the organization, so that everybody that has access to personal data knows what they need to do.
Okay. There's another question here. Let me just read it out to you. It's a bit technical though. It's writing here, will it be more of a challenge under this new law to use, I think he means your edge security services such as cloud storage or data processing than doing it locally, which I'm presuming he means saving the data on premise. So I'll take a stab at this first. I think it really depends as we use cloud services, and we're all using cloud services in some fashion today. Every company is, not just for security, but with other aspects. I think the point here is to talk with your cloud provider and IT, your IT team, to understand where the data is actually stored. Now, if you're operating in China, most likely a lot of it's within China, but that's just a question about the actual storage of it. Now, that's different from the application. The application might be offshore, but the data itself would likely be stored within a country, but you want to ask that question to determine that.
Yes, and there's actually other legislation that's already in effect regarding data localization when we're talking about the cybersecurity law. So we would recommend for any company that collects data in China to store the data in China unless it is absolutely necessary to have data transferred overseas. And then if data needs to be transferred out of China, you need to follow the requirements of the law, which would mean, for example, make sure that you have a contract in place between the company that is collecting the data and the company that receives the data overseas, whereby the company that receives the data overseas also undertakes to comply with the requirements of the PIPL and other data protection legislation in China. Because and on top of that, you would also need to notify and get the consent of the data subject that the data is being transferred overseas. So this might be something that you would want to have in some sort of contract that you ask data subjects to sign if they're employees or if they're customers. I understand it might be cumbersome for a security company that collects the data of visitors to a building, but I would say you could have maybe something shorter then, and then I would try to, I doubt that for every building you would need to necessarily transmit that data overseas. And one way that you can, if you need to get the data overseas for statistical purposes, anonymization, encryption, this is something that could help you, get away with some of the obligations, because once the data is no longer personal data, then of course the law doesn't apply to it the same way.
Okay. There's another question here. Somebody's asking, how does this impact MNCs, multinational companies, internal operations in China, like sending and storing employee personal data to systems hosted by the HQ outside of China? You sort of touched on that just now. Is there anything you want to add to that? It looks like a lot of companies are going to have to change some of their operations. And to this point, almost all the large cloud service providers, the Microsofts, the Apples, the Amazon, they're building data centers in literally every country, actually, I think, to satisfy these kind of laws. So anyway, anything you want to touch on that last question?
Yeah, I would say, so for example, employee personal data, I would make sure that the employees also sign the consent to transfer the data, and that there's also an agreement in place between the local entity and headquarters regarding the way that the data is being handled. When the data is being transferred, there's also other legislation that I didn't touch upon, but if data is being transferred cross borders, you would most likely need to keep a record, or the local entity that transmits the data will need to keep a record of all the data that's been transmitted, so that they will have a record of it and they will be able to say, look, this has been transferred to that entity, or this has been transferred to entity Y. Right. But it's important that also if you use subcontractors, you need to get consent to get the data transferred to subcontractors, and subcontractors also need to be responsible. They need to have the same kind of responsibilities that you have, and you will be jointly responsible for mishandling by a subcontractor.
Well, I'll tell you, as in Blue Ocean Security, as integrators, we are getting more and more requests from customers to comply with these kind of laws, and we have to fill out forms and even buy insurance for this purpose. So we're definitely feeling it in the market. Now, I also want to just to touch on this last question. I want to make a point here for everybody that this law is not yet in effect. It's coming in effect soon, and the people in China, we don't know to the extent of how everything is going to be enforced, and there might be some changes, but this is going to give you a flavor of how things are going to look like in the future. So there's one more question here. I think this is the last one. It's asking, is there a sound policy that can be used for like a large campus? I guess it's like, so basically like how do you, maybe you would agree with me, Tzachi, that I think you would have to build a policy based on your own specific situation and needs and the type of data that you're handling. You could either try to do this internally or go to a firm like Tzachi to help you through that process of building such a policy, and maybe even helping you audit your own situation of understanding where you are and mapping the data and dealing with that. There's a follow-up question here. Is there any sample for reference? Anyway, anything you want to touch on that point?
Yeah, I don't have a sample for reference yet. I think that the idea is that what we have right now are the requirements, and when you need to build this kind of program, you need to build it based on the organization's specifications. So what we are preparing now, and we're probably going to polish it as the law is being published, is some type of questionnaire that would allow an organization to start looking into their vulnerabilities and what they need to potentially keep in mind when they're preparing their procedures.
I think that's a great idea.
The idea is that we want to be active in helping companies build those procedures.
Okay, great. I think it's an awesome idea. Okay, I think we're going to wrap it up, Tzachi. Thank you, everybody, for joining us today. I hope this at least puts you in the right direction in terms of asking the questions. I would recommend, as we always do, to be a part of the solution for your larger organization. You don't want to stay just in the security area. So when you're talking to your IT professionals, to your other board of directors or other management, these are the kind of questions you want to bring up and help your organization to be more secure and more compliant with all the various laws in any district or jurisdiction that you are operating in. And anything we could do to help on that, we obviously want to help. We will be sharing this, again, we'll be sharing this recording to everybody on all the attendees and everybody that RSVP'd. And if you have any follow-up questions, feel free to reach out to Tzach directly. You can reach out to myself or to Blue Ocean as well, and we'll do whatever we can to help you. So once again, Tzach, thank you very much for helping us here today. And I think what we'll try to do is once the laws come out and we've had a chance to be exposed to it a bit more, maybe we'll do another webinar to talk about the updates and what we've learned at that point.
Yep, we'd be happy to do that. Thank you.
Okay,
and
very good.
Again for inviting me.
Awesome, thank you very much. And everybody that attended, thank you. And we wish you all a good evening. Thank you.
Bye-bye.